Well, the AG has today issued a statement challenging Parliament's power to use a resolution to control the process of admission into the Ghana School of Law, despite threats that he will be held to answer questions should the GLC fail to admit students who met the advertised pass mark. Excerpts of that statement is on your screen, and it reads, "Respectfully, I'm aware of the resolution passed by Parliament at its sitting on Friday, October 20, 2021, and in this terms, the General Legal Counsel is hereby directed to proceed and admit all the students who passed in accordance with the advertised rules of the examination." The Attorney General is a leader of the bar in Ghana, and he must see to it that the directive that 499 students who scored 50 marks are admitted to the law school. Now, whilst recognizing the general legislative powers of Parliament in Ghana, except as have been circumscribed by the Constitution, I am constrained to advise that Parliament is devoid of a power through the use of parliamentary resolutions to control the process of admission into the Ghana School of Law. The mode of exercising legislative power enshrined in Article 106 of the Constitution does not admit of resolutions. In accordance with Section 13(1)(e) and F of the Legal Profession Act 1960, Act 32, the power to regulate admission of students to pursue courses of instruction leading to qualification as lawyers and to hold examination, which may include preliminary, intermediate, and final examination, has been vested in the General Legal Counsel. It is correct that Section 1(5) of Act 32 stipulates the Council shall, in the performance of their functions, comply with any general directions given by the Minister. In my respectful opinion, this provision underscores the capacity of the Executive, not the Legislature, through the Minister responsible for the General Legal Counsel, and that is the Attorney General and Minister for Justice, to direct and advise the Council on major matters of national importance. And the notice also did not state the manner in which, all right, so it is in this regard, it is pertinent to indicate that by a letter dated October 18, 2021, received at my office on October 21, His Excellency the President forwarded the content of the petition of the 499 candidates to me for my comments in order to enable him respond. Another petition dated October 20 by National Association of Law Students was also delivered to Parliament, to the President. Upon delivery of my comments on the matters raised in both petitions, following further consultations with my good self by a letter dated October 26th, 3 clear days before the resolution of Parliament received at my office on October 27, the President directed me to, in pursuant of Section 1(5) of Act 32, make the necessary intervention to the General Legal Counsel on behalf of the 499 students to address the issue. Within the constraints of the law, I am following up on the directive of the President to make the necessary interventions on behalf of the 499 students. But that as it may, it is imperative to correct a few erroneous impressions contained in the impugned parliamentary resolution of October 29, 2021. The notice in the Daily Graphic of May 14 inviting applicants from suitably qualified Ghanaians for admission into the Ghana School of Law did not state a pass mark of 50% or any at all as a basis for admission. The notice stated applicants may be granted admission if they have passed the entrance examination conducted by the GLC. The notice also did not state the manner in which a pass mark set by GLC will be determined. It is clear, therefore, a contention that the originally announced or advertised pass mark was 50% is erroneous and insupportable. Insofar as any matter bordering on a pass mark is concerned, the notice in Daily Graphic stated the admission process is as follows. The General Legal Counsel determines the number of candidates to be admitted to the professional law course for the academic year. Applicants may be granted admission if they have passed the written examination organized by the General Legal Counsel for the 2021-2022 academic year on payment of the required fee and submission of the application form and all supporting documents required online. And so this is the statement that was issued by the Attorney General, and so it is copied. It's signed by Godfrey Dame, who is the Attorney General, and he says eligible candidates who attain the minimum threshold mark set by General Legal Counsel will be offered admission for the academic year. The GLC's notice was hinged on Section 13(1)(e) and F of the Legal Profession Act 1960, Act 32, which empowers the GLC to regulate admission of students to pursue courses of instruction leading to qualification as lawyers and to hold examination, which may include preliminary, intermediate, and final examinations. And this is actually signed by Attorney General Godfrey Dame and copied to Chairman of the General Legal Council. So in essence, what the letter is saying is that they are unable, the General Legal Council is unable to go by the directive given by Parliament, and the Attorney General says that Parliament has no power to actually hold him to respond to those directives. Let's get an interpretation of the law on this and speak with Kwekwan Sasari, who is former director of the Ghana School of Law. I'm grateful for your time, sir.
Thank you.
So you have been on this matter of opening up the professional law school for students to benefit. First, let me gauge your mood on what has happened with these 499 law students.
Thank you very much. I'm sure both of us are aware that the matter is currently pending before an Accra High Court or so. So I wouldn't like us to deal with a pending matter so that we can limit ourselves to the directive by the Speaker and the Honorable Attorney General's response. As far as I'm concerned, the directive by the Speaker is without any legal basis. And if it is implemented, it will amount to a naked usurpation of the functions of the General Legal Council. That's my first reaction. Secondly, nowhere in the Constitution has it been expressly stated that Parliament can intervene in such matters. Thirdly, the Legal Profession Act in Section 1, subsection 5 states clearly that it is the council, that is the General Legal Council, that shall in the performance of their functions comply with any general direction given to them by the minister. My understanding of minister in Act 32 is that the minister refers to the minister that the president shall assign certain functions to handle. Parliament is not a minister, and therefore Parliament should not wade into this unnecessary legal banter with anybody. I'm surprised that Parliament, will take upon itself something, to throw a red herring into the eyes of the general public. General Legal Council is the only statutory body responsible for the administration of legal education in Ghana. No other body. That the council conducts, that the entrance exam, comes under LI 2355. And again, it provides that the Ghana School of Law may grant admission to an applicant to undertake the professional law course if the applicant has passed an entrance examination organized by the council, not an entrance examination organized by Parliament. So the Parliament doesn't come in. Again, LI 2355 states that a person is not qualified for admission to undertake the professional law course where that person is, for any justifiable reason, considered by the council to be unsuitable for admission. It is a discretion that Parliament cannot question. The General Legal Council has spoken. It is only the Minister of Justice, not the Attorney General. I need to make this clear. It is not the Attorney General. Under Section 56 of the Legal Profession Act, the minister means the minister who functions under this act are for the time being assigned by the president. The Attorney General doesn't come in, Parliament doesn't come in, the Speaker doesn't come in, Ancestry doesn't come in. It is the minister. If Parliament has any complaints at all, he can do so on the quiet. But to bring the weight into this controversy publicly is the least I expected of Parliament to do. The three branches of government have their individual functions. Let Parliament limit itself to its legislative function as assigned it in Article 93, Clause 2 of the 1992 Constitution. I'm afraid I cannot go along with Parliament in this unnecessary directive that they have given.
Well, in the statement issued by the Attorney General Godfrey Dame seek to explain that the General Legal Council, in the invitation for candidates to participate in that entrance exams, did not promise them that they would get admission upon acquiring 50% mark. And I read excerpt of his letter. He says the notice in the Daily Graphic of May 14, 2021, inviting applications for suitably qualified Ghanaians for admission did not state a pass mark of 50% or any at all as basis for admission. And he said the notice also did not state the manner in which a pass mark set by GLC would be determined. But you have been a director of the Ghana School of Law. What has been the criteria all this while?
There has not been any set criterion or criteria. Every year, the council, which is differently constituted every 3 years, sets its own conditions for admission into the law school. The current governing regulations can be found in LI 2355, and it is stated in LI in regulation 5 of LI 2355 as follows. A person is not qualified for admission to undertake the professional law course where that person is for any justifiable reason considered by the council to be unsuitable for admission. Once the council has decided that for certain justifiable reasons, a candidate is not suitable for admission, so be it. That discretion cannot be questioned by Parliament. I'm afraid Parliament, cannot do that. And that is why I say that if Parliament tries to do that, it will amount to a naked usurpation of the functions of the General Legal Council. Parliament can. Now, I am not endorsing the Attorney General's views either that they did not promise. The Attorney General need not promise. The Attorney General is a member of the council. So the Attorney General need not, on his own, undertake any commitment. He doesn't have that power. It is only the General Legal Council that has been statutorily mandated to organize examinations for admission to the law school and to set the conditions for admission. Once they have set their conditions and in their collective wisdom, certain candidates are not deemed worthy of admission into the law school, nobody can question. If they have any complaints, let them go to court, not Parliament. Parliament doesn't come in at all. So this intimidation from Parliament is an abuse of legislative power. Parliament ought to know better that when they do that, the writing on the wall to the average Ghanaian is that you can say and Parliament can flex its muscles and pass you. I'm sorry, Parliament can't do that. They simply don't have the power.
Let's look at the requirement precedent to the exams. And thankfully, the Attorney General provides a bit of that in his statement. He says the admission process is as follows. The General Legal Council determines the number of candidates to be admitted to the professional law course for the academic year. Applicants may be granted admission if they have passed the written exams organized by the General Legal Council for the academic year on payment of required fees and submission of application form and all supporting documents required online. What's your interpretation of these requirements precedent to the exams and what has happened after the exams?
As the Attorney General has rightly pointed out in his response to Parliament, nowhere in the various notices from the General Legal Council and published by the Daily Graphic, nowhere did the Council undertake that any candidate who shall have obtained 50% shall be admitted into the law school. Nowhere. I'm yet to be shown any such commitment. Nowhere. No such assurance was given. Secondly, the Attorney General makes it quite clear that the notice did not state the manner in which a pass mark set by the GSC will be determined. So if anybody is aggrieved, then the person who feels aggrieved must look at the provisions of LI 2355 before embarking on any course. Because these are intending lawyers. They must be told that you don't gain admission into the law school through the court of public opinion. They shouldn't be encouraged to do that. They should be encouraged to study harder and pass next time, rather than what Parliament is trying to do. Parliament is creating a very false expectation in them. It is not legitimate. It is not legitimate at all.
I'm grateful for your time. Kwekwan Sasari is former director of the Ghana School of Law, and he's been interpreting the law on whether Parliament has the power to actually direct the General Legal Council to admit the 499 students who are aggrieved that they passed the 50% threshold and were not admitted.